while deciding the instant list. It is also humbly submitted that the issue in hand has significantly eroded public trust towards the judiciary as the organ of the state. Any such incidents as the one highlighted in the letter dated 25th of March 2024 should ideally be addressed internally by this Honorable Court or by the High Court itself, as the High Court is constitutionally empowered to devise its own practice and procedures. The public exposure of the letter and the ensuing proceedings have severely affected the sanctity of the judiciary as an organ of the state in the eyes of the public. Being a judge is not merely a profession but a calling, necessitating a sacred commitment to ethics and duty. The old adage of being above suspicion, like Caesar's wife, underscores the necessity for impeccable personal conduct and professional integrity. The basic oath of a judge, as provided in the Constitution, mandates service without fear or favor, affection or ill will, a directive that must be followed both in letter and in spirit. Failure to do so constitutes a violation of the solemn oath sworn upon the Constitution, carrying significant consequences. The judiciary primarily comprises the constitutional judiciary, the Supreme Court and the High Courts, and the subordinate judiciary, which is subordinate to the respective High Courts. The practice and procedure relating to the judiciary are addressed in Articles 202 and 203 of the Constitution. The Code of Conduct, established by the Supreme Judicial Council under Article 2098 of the Constitution, serves as the primary guideline for judicial behavior of superior judge. Although encompassing this code should not be seen as conclusive, it sets the basic standards for a judge's conduct, emphasizing that the Constitution declares all authority exercisable by the people as a sacred trust from Almighty Allah, indicating that justice in this nation has a divine origin. This underscores the full implementation of high constitutional principles and the universal requirements of natural justice. A judge's oath signifies complete submission to the Constitution and, by extension, to the law. Within these bounds, his function of interpreting and applying the Constitution and the law is essential for maintaining the rule of law across all human activities within the nation. The letter dated 25th of March 2024, authored by 6 judges of the Islamabad High Court, should serve as an eye-opener. It provides a framework to address any untoward incidents in the future. This Honorable Court should note that Article 204 of the Constitution grants the powers of the contempt of court, further bolstered by the Contempt of Court Ordinance. This ordinance empowers every superior court to address contempts committed in relation to it. The incidents detailed in the letter dated 25th of March trace back to the previous year. It is crucial for a strong message to be sent to the Parliament and the Executive and its institutions that no interference will be tolerated henceforth. An inquiry into these incidents should be conducted to determine what exactly transpired and why the approach judge of the High Court failed to act as provided under Article 204 of the Constitution, read with the Contempt of Court Ordinance 2003. It is particularly alarming that the 6 judges of the Islamabad High Court reported being approached and pressured without specifying the cases for the individuals involved. This situation necessitates consideration of why these judges were unable to issue contempt citations against such individuals. Next para I have already read. Para H. At the last hearing, the Honorable Chief Justice of Pakistan highlighted internal pressures within the judiciary, referencing the historical incidents. Past practices such as the appointment of monitoring judges for trials in subordinate judiciaries and the handling of political cases, including the formation of benches for such cases, demonstrate that approaches from the executive and its institutions were not the only concerns. The judiciary itself was implicated in these practices. A firm message must be sent to other state organs, and the judiciary's role in these internal approaches must be addressed. Incidents should be thoroughly investigated, reported, and conclusively resolved to prevent recurrence in the future and to uphold the integrity of the judiciary for generations to come. A comprehensive framework and code of conduct should also encompass judges of the subordinate judiciary. Given that Article 204 of the Constitution and the Contempt of Court Ordinance 203 apply only to the judges of the Superior Court, It is unjust to differentiate between the judges of the superior and subordinate judiciaries. While the regulation of procedures for the subordinate judiciary falls within the purview of the respective high courts, it is advisable for this Honorable Court, in consultation with all high courts, to devise a protective framework for the subordinate judiciary. This will enable them to operate independently and without impediments. An elaborate and reflective code of conduct established by the Supreme Judicial Council should... While judges of the superior courts possess the powers of the contempt under Article 204 of the Constitution, a mechanism for the subordinate judiciary to seek protection is also necessary, providing them both a shield and a sword against interference. The letter dated 25th March 24 and the anonymous complaint lodged by the subordinate judges of Islamabad gives a clear message to the public that judges in Pakistan are not free agents. These issues should be dealt with seriously on the administrative side, and public hearings will not bring any solution to the issue in hand, but will deplete the sanctity of judiciary in the eyes of the public. Without adequate protection mechanisms, judges of the subordinate judiciary may feel compelled to comply with undesirable demands due to threats of transfer to remote locations. The advent of social media has introduced new challenges that must be addressed. Judges, being human, are susceptible to emotions which should not influence their judicial duties. While maintaining opinions is natural, flaunting them can undermine the sanctity of their oath. Social activities of judges should be governed by specific guidelines within the Code of Conduct. Judges should avoid engagements with litigants, lawyers, associates or friends involved in their cases to prevent any appearance of impropriety. Participation in social events should be balanced to ensure judges are not isolated from social life, yet maintain professional integrity. Following incidents like one reported, it is advisable for the judges to limit their social interactions primarily to functions organized by the respective bar associations, which can provide controlled environments that minimize risk of inappropriate influence. As a reference, the practice adopted by the Kerala High Court could be considered. I'll skip that, my lord, and I'll go to R. If a judge of the High Court or a judge of subordinate judiciary encounters internal pressure from a fellow colleague or a judge, as well as any complaint regarding any interference from any corner, and lodges a complaint before their respective Chief Justice of a High Court, and if the Chief Justice fails to address the complaint within the specified time, then such judges of the High Court or subordinate judiciary should be permitted to file a complaint directly with the Supreme Judicial Council for appropriate redressal by amending the rules. My lords,
can you expand on this one? N must be, I mean, you just leave it hanging in the air. N.
My lord, N is something that we repeatedly...
Just read it, the advent.
The advent of social media has introduced new challenges that must be addressed. Judges, being human, are susceptible to emotions which should not...
What about the bombardment?
Well, that's exactly what I'm trying to
How does one deal with it? Issue contempt notices?
Yes, my lord, we have to not only put the executive to its work here. They have to stop this bombardment.
I'm not talking about executive. Now I'm talking about social media.
My lord, yes. Social media is regulated by the...
It's not regulated.
Well, it has to be regulated. PTA and the other sort of the agency that they have just set up, they have control over these social medias. And the Supreme Court Bar Association, your lordship might recall, we held a press conference saying that any kind of trolling of any honorable judge for maintaining any opinion that he has independently cannot be permitted. And our friends here from the press, they came rushing to me and they said that you are obstructing freedom of speech. The Supreme Court Bar Association from day one says that trolling of a judge for an expression that he gave in court proceedings is absolutely intolerable, and the executive branch, which is tasked with the regulation of this social media, must do its work, and we maintain that.
With great respect, speaking for myself,